Here is something worth thinking about. Your boss sends you a work laptop. You use it to check your personal Gmail during lunch. Does that give them the right to read your emails? The answer might surprise you. Welcome to Know the Law. I am your guide through the legal questions that actually affect your daily life. Today we are talking about workplace monitoring. Specifically, can your employer legally spy on your personal phone or personal email? We are going to break down exactly what the law says, where employers can and cannot go, and what changes depending on where you live. By the end of this video, you will know your rights. So let us get into it. The main federal law that protects your communications is called the Electronic Communications Privacy Act, also known as the ECPA. That sounds complicated, but the core idea is simple. This law makes it illegal for anyone, including your employer, to intentionally intercept your electronic communications. That covers emails, messages, and other digital conversations. Now here is where it gets interesting. The ECPA does carve out some exceptions. Employers can monitor communications when you give consent, or when monitoring falls under what the law calls the ordinary course of business. That phrase means regular, routine oversight for a legitimate work reason. But even that exception has limits. It does not give employers a blank check to watch everything you do. And here is something critical that a lot of people get wrong. Monitoring without any notice is not automatically legal, just because an employer claims it is for business purposes. The ordinary course of business exception specifically requires that employees receive notice before any monitoring begins. No notice means the legal protection crumbles. Let us talk about your personal phone or personal computer. The ones you own. The ones you pay the bill for. Your employer cannot legally monitor your personal email use on those devices during your personal time away from the workplace. Full stop. That boundary is protected under federal law. The same logic applies to files you store on your own device. If your employer happens to provide you with network access, they may be able to see which websites you visited while connected. But that does not give them a backdoor into your personal accounts or your locally stored files. Seeing that you visited a website is very different from accessing what is inside your private accounts or what is saved on your hard drive. Those are two completely separate things, and the law treats them that way. Now, what if you use a personal device but you accidentally download a work email onto it? That changes things slightly. Workers generally have a reasonable expectation of privacy for personal emails, except when those messages get downloaded onto or stored on a company-owned device. The device matters. If the machine belongs to your employer, the privacy calculus shifts. Here is where many employees get caught off guard. If your employer gives you a laptop, a phone, or a tablet, different rules apply. Using that device for personal email, personal messages, or personal browsing puts you in murkier territory. Your employer may have legitimate grounds to monitor activity on equipment they own, especially if they gave you notice up front. The safest approach is always to treat a company device as a work-only tool. A company-owned device is essentially their desk, not yours. Federal law sets a floor, but in many states, the protections go further. And if you live in one of those states, the rules your employer must follow are even stricter. Some states require employers to inform employees in writing of any monitoring before it begins. We are talking about specific written notice that details exactly what tracking methods will be used and when. That is not a suggestion in those states. It is a legal requirement. Other states require employers to provide specific notice right at the time of hire, posted in a visible location, along with a signed written acknowledgement that gets kept on file. That means your employer cannot slip monitoring into the fine print months later. It has to be disclosed upfront, on paper, with your signature on record. And then there are states with some of the strongest protections in the country. In those places, recording a conversation without all parties giving consent is not just a civil matter. Violations can carry significant financial penalties per incident and can even lead to criminal liability. In most states that have these stronger protections, the burden falls on employers to prove they gave proper notice, not on employees to prove they did not know about it. Let us make this concrete. Imagine you work remotely. Your company gives you a laptop and you occasionally check your personal email on it during your lunch break. One day, your employer accuses you of leaking company information and claims they read your personal emails to investigate. Here's the legal reality. If those personal emails were opened and stored on that company laptop, Your employer may have had some access under federal law because it is their equipment. But if they accessed your personal email account through network monitoring without ever telling you, monitoring was in place, they almost certainly violated the notice requirement of the ordinary course of business exception. And if you live in a state with stronger protections, they may have broken additional laws as well. This is exactly why knowing the rules matters before a situation like this ever comes up. So, what should you take away from this? Keep personal communications on personal devices. Use your own data plan when possible, not your employer's network. Check your employee handbook for any monitoring disclosures. And if your employer never gave you written notice of monitoring, that is a significant detail you may want to discuss with an employment attorney. Now you know the law. Hit like, subscribe, and share this with someone who needs to hear it. And drop a comment below with the legal situation you want us to break down next. The law affects every part of your life, and you might as well know how it works. Knowledge is the one thing they cannot take from you. See you in the next episode of Know the Law.